Good afternoon, everyone. My name is Evan Bradley. I'm the Chief Financial Officer for Campbell Property Management and one of the 5 owners of the company. I'm also a licensed CAM and work very closely with some of our largest HOA clients on major issues like document revisions. For those of you not as familiar with Campbell, we've been in business since 1953. And we manage over 400 HOA and condominium association clients from Dade all the way up to St. Lucie counties here in South Florida. I'm going to be the moderator for today's discussion on updating the governing docs of your association. And our legal expert today is Lisa McGill. She's an excellent condo and HOA attorney. We've had the privilege of working with her for many years now. Lisa is a member of the firm K. Bender and Rembaum, one of Florida's leading firms specializing in the field of community association law. They're also a leader in providing free education through webinars like this, periodicals, blogs, and they even have a radio show. So just as a reminder, this is for informational purposes only. This is not legal advice. If you need actual legal advice for your association, please consult your association attorney. So Lisa, thanks for being with us. Want to say anything about you or the firm?
Well, thank you. Thank you, Evan. Great introduction. I'm happy to be here. I see that you've had tremendous interest in this presentation. So it looks like a lot of community associations are interested in updating their documents. And I'm appreciative of the fact that you did have questions submitted in advance. So you and I spoke about some of those questions yesterday. We're going to be able to address a lot of them today, and hopefully everyone will have the information that they need in order to pursue this type of a project. I'm going to go forward and go ahead and share my screen.
Great.
Do you see that?
Not yet.
What do you see? No. What do you see? Okay. Why is that not working?
Oh. All right. So now.
How come this is not working? What do you see there? Do you see?
We see the PowerPoint, but it's not in the view show format.
That's very strange. Here, let's do that again. Okay. Sorry about this. I apologize. I'm sorry, give me just 1 second. I apologize for that.
You had it there for a second.
Oh, I did?
Mm-hmm.
Oh, okay.
That's the web form.
And what do you see now?
The web form, evaluation form.
It says that I'm sharing now. Let's stop and share again. And then, what do you see now?
Now we see it.
You see the actual jumping into the present. Okay, excellent. Sorry about that, everybody. A few computer quirks. So why the name of this presentation is why updating the governing documents of your association is critically important. And we're hoping to be able to answer some of those questions, because I hear that question a lot. Why do we have to update? If the law controls, then why do we have to change our documents? And there are a lot of reasons, but the first thing that I'd like to talk about is the governing documents themselves. What are they? And there's an hierarchy to the governing documents. So we have this divided up into 2 separate categories: the condominium and the homeowners association documents. I did not include cooperative documents here, but I can discuss cooperative issues throughout the presentation a little bit. But most of you are condominiums or homeowner association leaders and community association managers. So you have the documents that are applicable to each type of community. Of course, there's the declaration of condominium, the articles of incorporation, the bylaws, and rules and regulations or maintenance standards and policies.
So Lisa, a lot of people are asking, are all the documents created equal? And what if you find a conflict between one section of these documents and another?
Well, and that's a very important question, because in a condominium, the declaration of condominium is the document of highest priority, meaning that it is going to control in event of conflict between that and a lesser document. All the way down at the bottom of the list are the rules and regulations, your maintenance standards, and your policies. So anytime you have any rules and regulations that conflict with or are not grounded in the declaration of condominium, you're going to have a problem with enforcement. Those rules are just not going to be enforceable if there's a conflict, whether that conflict is inherent or implied. In a homeowners association, we have the Declaration of Covenants and Restrictions as the document of highest priority.
Mm-hmm. So then what happens if there's a conflict between the documents and the law? That question came up a lot in registration.
Okay, well, we're going to talk about that in a little bit more detail, but generally speaking, first of all, it's very confusing. It's confusing for community leaders, it's confusing for community managers, and it's often a subject of argument between attorneys, because there's a test that has to be evaluated to determine what is going to control. For our purposes and for your purposes today, if it's procedural or remedial, it generally, if the statute is procedural or remedial, it generally will control over procedures or remedies that are set forth in the governing documents. Example, the election procedure in a condo. Unless you've amended your documents in the last 20 or so years, you're not going to have the same election procedures that we're all familiar with. You're not going to have the 60-day notice, the 2-envelope system, and everything else that is required by the statute and the administrative code. But since that's procedural, that's how you elect your directors, then the statute is now going to control. Something that's remedial could be your remedies. Your documents may say that if in order to challenge or enforce the governing documents, you can file a suit at law, or you can do this, that, the other thing. Of course, in the condominium side, most of those types of disputes and enforcement issues go through the DBPR arbitration process before you actually file a lawsuit. So procedural or remedial. Substantive laws, and those we're going to talk about in detail later, will not be modified by subsequent changes in the statutes, and also of great public importance. So great public importance would be discrimination type laws. If your document had discriminatory language in them, and that was clearly in violation of the Fair Housing Act and all the other anti-discrimination laws, well, those provisions fall by the wayside, because that's a matter of great public importance. But other substantive issues are going to fall basically to the way the governing documents are, because the governing documents are considered a contract, and your contract, the benefit of the bargain is something that cannot be modified by laws after enacted laws, ex post facto laws. So with the governing documents, of course, your declaration of condominium, your declaration of covenants, always going to be of the highest priority. And when we think about a revision project, we're thinking about the meat and potatoes, what your rights and responsibilities are as an association, what your rights and responsibilities are as a unit owner, the obligations of the parties going back and forth ways, the responsibilities for maintenance, care, and protection of the property. It's all you want to think about in the document of highest priority. When we talk about your articles and bylaws, we're really talking about procedural issues. And then when we talk about your rules and regulations or your architectural guidelines, those are things that you may want to have some flexibility from time to time. So maybe it's not something that you want to have solidly in place in the governing documents that are voted upon by the members and recorded in the public records. You may want to have rules and regulations that you have a little bit more flexibility and that can change based upon the needs of the community.
Right. And there was a lot of questions about recording of rules. I think that law changed recently. What do the rules need to be recorded, and how does that work?
There are no cases that have addressed this issue as far as I'm aware. A couple of years ago, you're right, the HOA, the Homeowners Association statute, changed its provisions and said, it defined the term, quote, governing documents. So governing documents are included, all the ones that I listed here: declaration, article, bylaws, and rules. Well, in another provision of the HOA Act, which is Chapter 720 Florida statutes, it says the governing documents are recorded. Well, that means that your rules and regulations need to be recorded. What does that mean for all of you HOAs out there that don't have your rules or your architectural guidelines recorded? Well, my suggestion is that you do go ahead and record them. What about you all in the condominiums and cooperative associations? There's no harm, and actually I think it's always a benefit to record these documents, because then you'll have a record showing when it was adopted. Even if it's only adopted by a board vote, you'll have a record of when it happened, that the requisite vote was obtained, and that the procedures were properly in place to make sure that that rule goes into effect. If they're not recorded in the condo, it's not the hugest priority to go out and just immediately record what you have. I would rather see the association leaders work on what updates and changes they're going to make before they start just recording a mishmash of the different things that have been enacted over the years.
Right. And that brings us to another question. Some people have said, why not just make rules? If you have to have the owners vote on changes to the declaration, the articles, or the bylaws, why don't we just make rules to address all these things that might be a problem?
Well, because it's more likely than not, then the rules that you want to enact can conflict with existing provisions in the documents of higher priority, whether it's the declaration or the articles or the bylaws. And if there is a conflict, then the rules are going to fall. They're not going to be, excuse me, enforceable. So there's really a 4, even a 5-part test to rulemaking in community associations. Rules, you don't have the authority to create rules regarding the use of the property by virtue of the statute. That all comes from the governing documents. So you'll see in older documents that rules actually require a vote of the membership. And that's pretty cumbersome, and especially if you're changing rules that reflect the hours of operation of the pool, or how you obtain your laundry cards, or the office hours and what have you. But the documents, and there's another big distinction between rules and provisions that are in the declaration, is that rules are subject to a reasonableness analysis. So something in the declaration may be considered unreasonable. It can't be unconscionable or wholly arbitrary, but it may be considered unreasonable but still enforceable. Something that's in your rules, the board or whoever the body is that's adopting the rules will really need to be able to justify why they adopted that rule, or why was that rule necessary. And necessary or appropriate for a community can be based on aesthetics or order, and some of the things that we often think about in community associations. But again, it's definitely subject to that reasonableness rule. Right. That reasonableness test. I'm sorry, I shouldn't say reasonableness rule, reasonableness test. So no, you can't make changes just to your rules and regulations and pretend that that's going to be hunky-dory and serve all of your needs.
Right. So we established we can't just make rules. So we're going to actually have to amend our docs and go about getting a vote of the owners. So how does the association actually do that?
Okay, well, I have a lot of information. There's a lot of meat potatoes we talked about on this slide. And there are questions on how you start, how you go about it, and what do you do in order to effectuate those amendments. Well, number one, you need to have an idea of how you want or what you want to amend. And when we talk about amending and restating the documents, we're generally talking about updating pretty much everything. So we're going through all the documents, either line by line or document by document, and addressing what the law was at the time that the document was written, what is the law today, what types of case law has impacted the analysis of the way that that language of your governing documents, and what do you want going forward. From the attorney's perspective, I always look at definitions, I always look at assessment collection, I always look at maintenance responsibilities, because that's where we see a lot of disputes, like who's responsible for this, who has to fix that. We look at enforcement of maintenance responsibilities. So can the association go in there and fix something if somebody, if an individual owner just neglects to do so or refuses to do so? I always think about that enforcement provision. And then of course I look at insurance, I look at reconstruction after casualty. Now that's not the stuff that my boards typically look at. I mean, maybe they'll look at enforcement, that's for sure. But the board of directors, they look at how does it affect me on a day-to-day, on the ground, living there? Use. They always want to talk about use. So that's the parking, that's the leasing, that's the alterations and improvements, that's, you know, pets, that's all the things that you talk about your physical living. So think about, what do you want to do? Do you want to host scale, bring everything up to date? You want to just tackle problem areas? So that's something to think about and to talk about with your counsel to see what you're going to get the best bang for your buck.
Right.
I often find that piecemeal amendments, if you really want to do a lot of work, it requires more work, more effort, and you don't get as much of the benefit as you may get by amending and restating the document as a whole.
Right. I think you got to take the pulse of your community too. I see some boards that have a wish list of items that they would love to have in the documents, but the reality is they just could never get enough people to vote for that. For example, some board members may want to ban rentals. Well, if you already have 25% rentals in the community and you need 75% vote, it's just not going to happen. So you really need to understand what's feasible versus what you might want when you go through this process.
You're exactly right. And if there's something that that's somewhat unclear, I often recommend that the board conduct a straw poll, or we handle the amendments in phases so that we can actually make changes throughout the process based upon the owner's needs or the owner's desires, because you don't want to embark on a huge project unless you have a notion that there's going to be success in the end.
Right. Yeah. I tell the boards we work with, if you don't have unanimous agreement on your board that this is a good amendment, it's highly likely it's going to be just as divisive, if not more so, in the community. So you may need to move on. But so once we've decided kind of what we want to amend, working with the management company, the attorney, how do we go about getting this done?
Okay. So I have a laundry list of things here. Meeting versus written approval. The statute does not say what method of amendment is required. Sometimes the governing documents will have both options available, saying, or sometimes they'll just be very vague. These documents may be amended with the approval of 75% of the members. Well, that doesn't specify that it has to be at a duly called meeting with 14 days notice in advance, or whether it's in writing by somebody signing off of the form. Something you want to take a look at. The only difference between using a meeting and the written approval process is that there are a little bit more logistics associated with the meeting. You have to actually send physical notice of a meeting, hold an actual meeting, and you're sending limited proxy forms rather than sending written approval forms. Now, most of our owners are familiar with what a limited proxy is, but sometimes you do see some confusion with that. The written approval process, the really only drawback is, and there's actually arguments that are on both sides of this coin, but is the time limit associated with collection of the approvals. If you're operating under the statute, the Not-for-Profit Corporate Act, then your written approvals all have to be dated within 60 days of each other. So that doesn't mean from the date that you mail it out. And if you think you're going to have some kind of issue with the timing on a written approval, you don't have your board members immediately sign and date their forms the same day that you mail it out. You wait for some of the other forms to come in because that is your beginning date, and then you have your 60 days. With a proxy, we know that the proxy can be valid up to 90 days. The meeting can be adjourned up to 90 days. So if you have 30 days notice of a meeting, or even 45 days notice of a meeting, you try to collect whatever you can beforehand, you get to the meeting, you realize that you don't have enough, you can adjourn 30 days, try to see if you can get a few more people to vote, another 30 days. So you have a little bit of time there to ensure that everyone has the ability to express their opinion about the amendments.
Yeah, that's a good point. You can call in that meeting, gives you a little bit more time. And when you have those high vote requirements, that can help quite a bit. So, so you've sent this out. I mean, can the board go door to door? Can the board advocate for a position on changing these documents? I've heard people complain that, the board shouldn't be doing that or can't do that.
I mean, there's really no reason it can't. I mean, obviously the board is proposing it. The board voted in favor of it. The board feels that there's a need for the amendment. Mm-hmm. Yes, I mean, when it comes to use issues and not the legal issues or the governance issues, but when it comes to use issues, sure, people are going to have differing opinions. And also when it comes to changes that the owners perceive or provide the board with additional powers and authorities. So the board members, they just need to be judicious about it. Why are we supporting this? Is there a party line as to why that we support this? As individuals, we're all entitled to our own opinion. So as an individual, we can, talk to our neighbor, talk to our friends, talk at the pool. But do we as a board want to have a party line on the benefit and why we're asking the members to vote on these amendments? And I think it's pretty effective, and maybe you have a little bit less of a position when it comes to actual uses.
Gotcha. And I'm just going through the chat here. I think a few people are looking for clarification on changing rules versus changing the documents. Can you just revisit that again? Who can change the rules versus who can change the other documents that were listed?
Well, generally the declaration, articles, and bylaws, and almost all of the cases will require a vote of the membership, and that vote will be stated in the documents themselves. It could be a percentage of a quorum of members. It could be a percentage of the whole of the members. It'll say you need 2/3 of the members, or 2/3 of the members voting at a meeting, or some other level of approval. Rules and regulations, for the most part, your articles and your bylaws will say that one of the board powers, and you can take a look at that section that says board powers, and there's a whole laundry list of things that follow it. The power to make and enact rules and regulations regarding the use of the property, or make and enact rules and regulations regarding the administration of the association, or something along those lines. If there is no rulemaking power in the governing documents at all, then the statute does authorize the board to enact certain administrative rules, but you're going to want to talk to council as to whether the board does have the authority to go forward and make those rules. So that's number one. The board has to, if the board's going to be making a rule, the board has to have the authority to make the rule. Number two, if the board does have the authority to make the rule cannot conflict with any of the documents of higher priority. So that's either an express conflict or an applied conflict. Number three, the rule has to be reasonable. That term reasonable is very hard to define. It's like beauty in the eye of the beholder. But generally, the way it's defined is that the rule there's a legitimate need or a legitimate benefit, association benefit for having the rule or enforcing that rule. Of course, you have to follow your procedural requirements. So that would either require a 14-day notice if it's a rule regarding unit use, or a rule regarding a particular architectural parcel in an HOA, and or 48 hours for rules regarding common element use and maintenance. And then also, of course, the rule cannot violate important public policies. So we have a federal statute, or certain federal statutes. We have a federal statute that says owners are allowed to install the small satellite dishes on property that they own or have exclusive use over. And the board cannot go ahead and adopt a rule that says no satellite dishes, because that would be in violation of the federal law. So that analysis needs to be conducted, because I can tell you, I review rules and regulations all the time that have either been from the original developer or have been modified, 18 times over the years. And a lot of the times we will find that there are problems with the enforceability of those rules based upon that implied conflict analysis for the most part.
Right. Okay. Another topic that's come up recently, you mentioned voting and written consent, is online voting, obviously due to the current pandemic situation.
Mhm.
Are you seeing associations move to online voting to take some of these amendment votes?
Yeah, I think electronic voting, it's an option for all the community association properties that we have here in Florida. I think it's fabulous. I mean, it really makes your life so much easier, and it's a very easy process to implement. And it's just a matter of which owners decide to opt into the electronic voting. But it also can reduce your distribution costs, because if you have electronic voting and electronic distribution, you're not sending a package of 50 pages to 175 owners. You're emailing them or uploading the amendments for people to be able to read, digest, print on their own time. And it's not, you don't have the expense associated with the duplication. You don't have the expense associated with the actual mail costs. You don't have the time, the lag that you have with the mail costs. I mean, think about all these people that are in other countries. When are they going to receive their materials?
Right. Yeah. We're seeing some of the same trends. I do think it's important to point out you can't force people into online voting. So you do end up running kind of two systems. You're still going to run a partial paper system and then an online system. But it's certainly the trend in the marketplace, and communities are catching on. So anything more about how an association should be going about this process?
Well, I mean, I do mention the leasing or leasing or rental restrictions in the condo field, and this may be something that we'll see for HOAs within the next year or 2 years. But several years ago, 2004, I believe it was, the condo statute was amended to say that changes to the rental restrictions, limiting the number of rentals or the duration of rentals or how many rentals can be permitted per year, only will apply to people that vote in favor of the amendment or people that purchase after the effective date of the amendment. So when you're thinking about leasing restrictions in condos, you really have to think about how you're going to go about keeping track of who's voted in favor and what units have sold and which ones go into the enforceable category, and how that's going to impact your operations and your enforcement if some people are just not subject to the amendments that you'd like to implement. So I always like to make that clear. Material amendments, there are certain types of amendments that you can't amend without a super majority of member vote. Those are not things that typically the boards are all that feel all that important. Those are more things that the attorneys feel all that important. And then for mortgagee approval issues, there are, if you have a mortgagee approval requirement, in most cases, it's going to be enforceable under certain circumstances. So it's not impossible to obtain mortgagee approval. And the way that the systems are right now, you can move forward with an amendment so long as the mortgagees don't respond to certified mailings within a certain period of time. I only bring it up because it's an additional expense. There's additional time associated with the mortgagee approval process. So therefore it's an additional expense on your part. But really it's your push, just like you said, for the board or a committee or even staff members, it's the get out the vote push, and having a meeting, maybe a town hall meeting before the actual vote to talk about what's being changed and to find out what concerns people have is also very effective in encouraging them to vote when the time comes.
Yeah, we've sponsored several of those, and it's a huge, it's great to get community-wide input before you go too far down the road. You may find out quickly some things you thought were going to be no-brainers are highly contentious, and you may figure out that you may have missed some things that the community finds valuable. So we always encourage town hall meetings early on in the process, so you do get that feedback, and people don't feel caught off guard by the process.
So now we come to actual document provisions and what isn't contained in those documents.
Right. So I think, yeah, you've got some true false questions here that are going to kind of help people understand maybe what they're missing by not updating their docs.
Right, exactly. So let's go to our first question. And I put these together, but the first question.
Yeah, is a foreclosing lender required to pay 1% of 12 months of delinquent assessments automatically?
And when we do this in person, I always ask for people to raise their hands. Some people do, some people don't. But lo and behold, the answer is actually false. Why is that false? Everyone knows the statute says 12 months worth of assessments or 1% of the delinquent debt. Why is it false? Why? Because you may have old language in your documents that gives mortgagees a total free ride, so they don't have to pay anything. Moreover, you may have language in your documents that not only gives the mortgagee this protection, it gives third-party purchasers at foreclosure sales this protection. So it's one thing to lose your 1% or your 12 months, and it usually works out to be 1% because that's the lesser, it's the lesser of the 1% or 12 months, but you really lose tremendously if you have some investor purchase at a foreclosure sale. There's $18,000 worth of delinquency out there. You think as a community association, oh wow, good, the lender didn't buy it or the lender didn't take title. That's great. We're going to get our 18 grand or more. And lo and behold, they send you a letter saying, oh, sorry, we're not paying because your documents say we don't have to.
Right. Just changing that one provision could pay for your entire document amendment process, really. I mean, just one of those. So next one, does the board have sole decision-making power when it comes to filing a lawsuit?
And you would think so, but it's mostly, I say mostly false. Because in the HOA side, there's a statute that says if the association wants to file a lawsuit where the amount in controversy is over 100 grand, then they have to have the members vote to authorize that lawsuit. Where do you think this came from?
Somebody made a mistake, would be my guess.
Or the developers. The developers were saying, hey, listen, this board's going out and suing me all over the place. The people are saying they don't even know about it. So we want to make sure that the board is not just running amok and going out there and filing lawsuits against me, particularly the developer or the contractor or the architect or others, until the members really know about it. So it really, again, it's the reason I include this is because what you see may not be what you get. What you see, like the written word, may not be exactly the way that it's intended.
Right. And just from the management side, I would advise all boards to be very wary of lawsuits in general. Legal fees for litigation for an amount under 100,000 can easily exceed 100,000 very quickly. I've seen it exceed 200,000 on a $40,000 dispute. Do not ever enter into litigation on principle or because you think something's not fair. Litigation is always a business decision. It has nothing to do with who's right and who's wrong. So
unfortunately, you're correct. I mean, you'd think that we have a justice system that's to make things right, but it doesn't necessarily work that way. So you really have to think hard and long and about what you're trying to gain and whether or not it's going to be productive for you. Now, nobody can really accurately predict what lawsuits will cost because sometimes they run the way that they should, other times they run amok. And it's really very difficult for anyone to accurately predict what the costs are going to be. And it's even more difficult to predict what the results are going to be, because I've seen so many times where my board was 100% right. They didn't do anything wrong. And then they lost it in litigation. And it would just kill me because I know that they didn't do anything wrong. And then I've seen boards that skirted through certain things. And I was really nervous and I'd be awake at night thinking that this lawsuit's going to go down for them. And then they would win. So no rhyme or reason to it.
Right. Next one, all new owners go through the screening process in our community.
So do all new owners have to go through the screening process?
Mm-hmm.
That's false. Now you're seeing a pattern here. I'm going to put all these up there. Screening is not really the greatest word, but that's what everyone calls it. Screening, if you take a look at the governing documents, is only authorized by virtue of your declaration of condominium or your declaration of covenants. And it typically only pertains to sales or to leases. Sales or leases. It doesn't pertain when new people are moving in after the original purchasers bought. It doesn't apply to the boyfriend or the girlfriend that's staying there for more than 30 days. It doesn't apply to the son that's coming home from college or the son that's getting out of jail or whatever it may be. So you need to take a look at those documents carefully. If you want to be able to screen people, like all just people that are living there, because you want to know who's there, how many people are there, what kind of cars they have, that kind of thing, you're going to have to update your documents to give yourself that ability. Now, most of the mortgagee protection clauses say that mortgagees don't have to go through the screening process when they want to sell their place. Don't worry so much about that, because whoever buys it is still required to comply with the use restrictions. So if somebody buys it to be the new house on MTV, party house on MTV, just because they didn't go through this approval process doesn't mean that you can't enforce those restrictions against them. And then also, what about inheritances? What about other operations of law? I mean, do those screening provisions apply? So that's something, this is one of the things that we change almost universally when we do updating projects, because everyone is under the false assumption that the screening process is for the purposes of the board saying yes or no to a purchase or a rental, and that may not be the case in your governing documents, and there's very limited reasons under which a board would be able to reject a transaction.
Gotcha. So the next one is, once the law changes, is the change automatically applicable to your community?
So this is what you asked about a little bit earlier, and I basically answered it. The law will apply if it's procedural or remedial, but just like that previous example with the 1% or the 12 months, if the governing documents say a new purchaser owes nothing, well, that's a substantive right of the new purchaser or for the mortgagee, and that is going to trump over the 1% or the 12 months worth of assessment. So those are some of the things that you want to think about, because you do want to be able to take advantage of positive changes to the law. Over my entire career, most of the changes to the Condo Act and the HOA Act were always consumer-oriented changes. It was always about the owner, the owner, the owner. In the last 3 or 4 years, we've seen more of the changes tend towards the developer or the entity and protecting them. So again, you never know what's going to happen in the future, but I typically recommend that associations include something in their documents that says new laws will apply to them. And that way you're promoting predictability going forward.
Gotcha. Can the association prohibit clotheslines or solar panels in a community?
Well, I think people are becoming a little bit more savvy to what the law says about renewable energy devices, but there is a law in Florida, 163.04, that says the association cannot prohibit energy devices based upon renewable resources. So clotheslines, I don't see that really becoming much of an issue. As long as the clothesline is not visible from the street, nobody really cares, and most people don't even use clotheslines in Florida. It rains here so often and there's so much humidity, you don't even get the benefit of having your clothes dried in the open air. But solar panels are becoming much more popular, and as an association, you're restricted on what limitations that you can put on owners desiring to install solar panels on their own property, on their roofs. And we wouldn't be in a condo where there's a common roof. There's also some other things that you may encounter from time to time. Rain barrels, again, for a condo, you're not going to have this issue, but some people are very environmentally conscious. They may want to have some rain harvesting. I've seen some people buy compost barrels, which is really not obtrusive whatsoever. I wrote on my notes wood burning ovens. I've never seen anyone want to install one in an HOA where it's been an issue that came up to the legal side, but I mean, it could happen. I mean, pizza ovens, people want to have a nice wood burning oven. So when you're thinking about your architectural control requirements, also think about, or at least provide yourself with the flexibility to be able to consult with counsel before you just say, no, nothing allowed on the roof. Nothing allowed on the roof? No. Let's think about it. Let's think about how you can control the colors, the placement, the appearance of it, but not a plain no.
The next one is, can our community enforce rules prohibiting minors from using any of the recreational facilities without an adult present?
Okay, well, I wrote false, but this is a different answer if you're 55 and over or housing for older persons community. So discrimination laws, everyone's familiar with the typical discrimination laws, race, national origin, religion, and what have you. The laws also prohibit discrimination against families with children. That means being someone of age that has custody of a minor child. If you're 55 and over, you've already taken the steps that you need to take in order to be exempt from that one little portion of the discrimination law. So that's why in 55 and over communities, people under 18 generally are just not permitted to live there. People under 18 may be restricted from using the pool during certain times of the day, or from using the clubhouse after a certain time, or using the billiard hall. But communities that don't qualify from the exception, yes, they cannot have rules that are solely based upon age or that discriminate against families with children. And we've seen many instances in the last several years and years even before that, where associations innocently were enforcing rules that were in their documents and were accused of discrimination and ultimately had to pay penalties or engage in other remedial actions as a result of those rules and regulations.
Gotcha. Next one on the list is, are material alterations to the property always prohibited unless you would obtain owner approval?
Okay, let's see what I wrote to this one. Okay, well, this says false. I would say it's mostly false. In the condo side, we know that there's a statute that says material alterations or additions must obtain the approval of 75% of the members or whatever's provided in the documents. So your governing document of a condo may say that the board can spend up to 10% of the annual budget on alterations, or your board can spend up to $50,000 without having to obtain a vote of the membership. And I think that that's a pretty important provision to have, even if it's limited in the spending authority, because everything seems to be considered an alteration or improvement. I mean, I've seen cases where painting in the garage, how garages are and how tight they are, where you paint the bottom part of the poles in the garage bright yellow or bright orange to make them more visible, that was considered an alteration that required a membership vote. I mean, it's crazy. So you want to have some flexibility. On the HOA side, we don't have a law that says you need membership approval, but conversely, maybe you want to have some kind of spending limitation for the HOA boards. Maybe you don't want a board to go out and spend $1 million creating a new pool room or billiard room or racquetball court or something. Maybe you want the members to have that level of control. I also have on here, there are some exceptions for code compliance issues, obviously, but the reason I put this issue in here is that for the condo side, I always encourage, you want a little bit of flexibility. Maybe you don't want your board to have total control, but you don't want to have every single decision be so so concerned with whether something is an alteration or a maintenance item. I mean, tiny little things, putting down stepping stones where there's a muddy area. Do you want to have to go through a whole vote for that? It just doesn't make sense. And on the HOA side, maybe you do want to have some limitations on the expenditures, right?
Mm-hmm. So delinquent assessments, do they automatically accrue at 18% annual interest and a $25 late fee?
No, that's false. So late fees are not automatic. They have to have the authority to charge the late fee in the governing documents. Most contemporary governing documents will have the late fee in there, and it won't specify the amount of the late fee, although I've seen some of them that say $1 per day up to 30 days, which of course exceeds the $25 that is permitted on the condo side. And some of them will say $10. So you don't want to be in the position where somebody doesn't pay you and then you can't collect 25 bucks for every month they haven't paid. You want to be able to collect the highest amount that's allowed by law at the time. And again, some of the older documents will say interest accrues at the rate of 10% or 8% or what have you. And that's just something that you want to update to make sure that going forward, you're going to be in a better position to collect as much money as you can.
Right. Okay, so the next one on the last question on the list, if a pipe in a wall only provides service to one unit, is that unit owner responsible for its maintenance?
This goes back to what I said at the beginning. When I look at governing documents, I always look at maintenance responsibilities. And I don't know I may not know the actual physical configuration of the property or how things are working in the property, but I do know that I want there to be clarity when there is a dispute over who's responsible for what. So in a condo, the declaration of condo will describe the boundaries of the unit, and then we'll allocate the responsibility for maintenance and repair. And that's different from insurance reconstruction. That's a whole topic for another day. But that is something that we see many, many lawsuits over, many, many disputes over. If you pick up my tile on the balcony because you're going through concrete restoration, who has to pay to put the tile back? If I have a mirrored or some kind of fancy wall treatment and there's a common pipe that burst, the association needs to break through the wall to repair the pipe. Who's responsible to pay for that fancy wall treatment? These are things that you want to have delineated when things arise. This is where we see a lot of disputes. I'm sure you've seen them too.
Oh, management would appreciate that being clarified as well. Trust me. So I guess, a lot of people asked kind of what is the risk of not updating the docs? What's the downside of not updating the docs? Why should we update the docs? That was maybe the most common question that got asked. What are they giving up by not going through this process?
Well, you may be giving up. I mean, you may be losing money, or you may not be able to take advantage of laws that come about subsequent to the date that your documents were written. But really the reason to do it is to make the documents fulfill your needs. A community is envisioned by a developer who, may have an idea who's going to live there or may just want to be able to sell to anybody. But as the community matures, things become known. What do we want? How do we want this to be? Do we want it to be in a way that serves our needs? So you want it for clarity purposes, number one. You want to know who's responsible for what, and whether you look at the piece of paper, is the piece of paper going to control, or is there some other law out there, that totally puts a wrinkle in your puzzle. You want to be able to take advantage of the new laws that are beneficial for community associations. You want to be able to do some of the things that you thought you were always able to do, but really not, but you got away with it, for so many years. And you want to be able to, of course, capture as much revenue as you possibly can in the event of a delinquency.
So we, like you mentioned, we had taken some questions from the audience. Some of them fit into our presentation, and some of them I kind of saved for the end here. So why don't we go through a few of these that were submitted in advance. This one was very popular. What are the top 3 most important things you recommend reviewing or changing in a document?
Well, it depends if you took them about from my perspective as legal counsel or from from perspective from board management. But that screening, that sales, that leasing approval process,
Right.
if it hasn't been updated in particularly the last 10 years, but it hasn't been updated at all, it needs to be done. It really needs to be done because you may be running afoul of what it says in your documents. A lot of the older documents don't even give the board the right of approval. It just says right of first refusal. Well, no one's gonna like find a new tenant because they don't like the tenant that came in. It just doesn't work that way. But that's the way that they were originally written. So you want to be able to clarify that provision, allow yourself to obtain the background documentation that you need, give yourself the ability to do that, and then the ability to reject a transaction under certain circumstances. If somebody's a sex offender, you don't want to approve the transaction, or some other instance where, where the new ownership or new occupancy can really change the dynamic of the community. Obviously assessment collection. If your documents are old, you don't have good assessment collection provisions, you want to update those. And enforcement provisions, tailoring your enforcement to the type of issues that you confront so that hopefully you can avoid having to go through the arbitration or litigation process. So really one of the biggest reasons to change your documents is to try to avoid future litigation.
Right. From management's perspective, I would say the hottest topic right now is probably short-term rentals, Airbnb, VRBO. That's probably one of the most important ones we see boards trying to address. Again, it can be difficult, but it's an issue that is very hot right now. Is there an issue that is in old documents that you come across that you find to be particularly damaging that should be removed?
Well, there's a new law in Florida from 2020 that allows the board of directors to remove a racially restrictive covenant. We don't really see them that often in Florida, but anything that's going to subject yourselves to liability is something that you really want to remove. Plus also the mortgagee free ride or the third party purchaser 3 ride. So something that's really going to hold you back, you want to immediately eliminate.
Right. So how do we make changes if the owners won't vote? That was really common. I'll handle that. I mean, we help a lot of boards with this project. It is a difficult process. Like we talked about earlier, you need to communicate early and often. You need to have town hall meetings. You need to educate people on why this is important. And then once you've done all that, you have to do it the old fashioned way. You have to get out the vote. That means going door to door, maybe robocall or robotext, blast email. Give yourself plenty of time. We mentioned calling a meeting can give you as much as maybe 120, 150 days to get the proxies in that you need. And there are some tricks of the trade, candidly, that we've done this a lot and we can help you with. But you can't just assume because you have a great document that people are going to care. You have to educate them on why it's important. So the next one was, what is a reasonable budget for a document change?
And that depends on what you want to accomplish. I mean, if you're only tackling certain areas, you may be spending $2,000 to $3,000. But again, those are very limited. I would say generally, okay, there's a million caveats that go into this, but I would say that redoing an entire set of documents for a single property or a single condo association, a single HOA association, you should give yourself a budget from about $12,000 to $16,000. And I'll tell you that, I mean, that goes a really long way because if you even undertook amendments to 15 different provisions, you could be at the $8,000 range, $8,000 range, and then you're not getting the benefit of all the other things that would automatically be included if the attorney was just, doing this for you. So think about it. Talk about with your attorney, what is it that you want to accomplish? I mean, if you really just want to tackle your problem areas, tackle those problem areas. But if you want to be more streamlined, make everything consistent, bring it all up to date, you really have to think about the expenditure there. And
Right.
that's excluding, of course, if you need mortgagee consent.
Right. And then that brings us into time. Now you've allocated the budget, but how long does this take?
It depends on the community. Some communities like to bifurcate the process, where if you have a 75% of the whole requirement, or you have some other types of limitations in the documents themselves, sometimes they want to just tackle making that change, bring it from 75% of the whole down to 2/3, or bring it to 75% of the quorum. That way, the people that are not participating aren't essentially punishing the people that are participating and want to get something done. So you bifurcate that process. To actually get the amendments, if you're talking about a full rewrite, to get them into a position where everybody on the board is comfortable and you've had that town hall with the owners and maybe made some revisions after that town hall of the owners, I would say 6 months, 4 to 6 months on the front end. And then once they're ready they're ready for the vote, then I would give yourself, again, another 3 to 4 months, or as much as you possibly can, to make sure that you get everyone to vote.
Yeah, I agree. In my experience, to do a full rewrite, you're looking at almost a year to really get through it all. If you're going to get all that input, and you can only move as fast as volunteers can move, and so allocate plenty of time is the short answer. Do not expect it to happen quickly. How often should the docs be updated? And I looked in the chat. There's some questions about the Marketable Record Title Act too, and I think that kind of jives here. So what do you think about that?
Well, if there's something that's causing you a problem, update it whenever you realize there's a problem. So don't wait for a whole-scale project to tackle a problem area. Definitely do that as often as you need. Now, the statute changes. Well, it changes every year. And sometimes those changes are significant, and sometimes those changes are ministerial. But typically you're going to want, if it hasn't been done in 20 years, it needs to be done, okay? If it hasn't been done in 10 years, it probably needs to be done. But if you did this 5 years ago, you may just want to tackle whatever problem areas, or have someone take a look at your review and see if anything has changed since the last time that you accomplished the project. So it's as often as is necessary to meet the needs of your community.
Right. I think we covered these last two already, but obviously, yes, a vote to amend docs can be taken electronically. And again, getting members to vote is all about, getting out the vote. Another question I saw in the chat that came up a couple of times, people were asking about Kaufman language. I think that's commonly discussed when amending docs. Can you touch on that for a second?
Yeah, that was something that we talked about when, does the new law automatically apply? Mm-hmm. And there was a case, Kaufman versus Sphere, from way back when I was probably in elementary school, hopefully. And it said that if the documents say, if in the Declaration of Condominium, under the definitions, it says this condominium is subject to Chapter 718 as it is amended from time to time. It wasn't Chapter 718 back then, it was Chapter 711. But again, this community is subject to the law as they are amended from time to time. That's considered Kaufman language. And when you have Kaufman language, the changes that happen in the statute that may not apply to everyone because they're substantive in nature rather than being procedural in nature will typically apply to you. It promotes predictability. Having the Kaufman language, as I said, promotes predictability. A lot of times you'll see in all the new documents, I think I see, it says this community is formed subject to Chapter 718 as it exists on February 2018. It'll have a date certain, because the developers or the people that are creating these communities also want predictability, and they want to be able to judge their potential future exposure based upon what they know, not what may change over time. So that's something to also think about with your counsel. I think most attorneys do recommend adding Kaufman language solely for the predictability issue. As I said, for the bulk of the time of my practice, all the changes have been consumer-oriented changes. Now we're seeing that tide turn a little bit, but again, it's hard to hedge your bets on what's going to happen in the legislature going forward.
All right. Well, it's 1 o'clock, so At this point, I think we've pretty well wrapped up. There's still a lot of questions in the chat. Unfortunately, I think everyone can see this is an incredibly complicated topic. There's a lot of analysis that goes into it, both from a practical management standpoint and from a legal standpoint. And hopefully, although you learned a few things today, we highly recommend you consult with your management company and attorney before you get too far involved in a process like this. It's expensive. There are a lot of pitfalls, but it really is necessary, especially if you're an older community. So we highly, highly recommend that you get professionals involved if you're going to go down that road. You have our last slide there, Lisa?
Well, yeah, so before, let me stop my share. So before we conclude, I definitely want to remind everybody, there's going to be a poll that pops up for you to answer. And if you're a CAM, a licensee, it's right there. I see it. I'm not allowed to vote though. If you're a CAM, you will be directed to our survey through KVR, K-Vendor Runbound, because we need that survey in order to report the credits to the state. So that's very, very important. Working with a great management team always helps, because when you have people that are experienced and know how to get things done on the ground level, it really works out helpful to you. And then also sometimes Ashley will send me the questions. So if I do see a pattern of questions that I can answer in an email, I'll give her those answers and she'll be able to disseminate them to the participants today.
Great. So by default, all of you on the call are registered for Campbell's blog and newsletter. Check your email box for announcements, blog articles, and opportunities to register for future webinars. And as Lisa said, the CAMs on the call will be automatically directed to their evaluation form. So thank you, everyone, for coming. Hope it was fruitful, and we look forward to seeing you again at a future webinar. Have a great day. Thank you.